should.
But how can we say that? So you can shake your head all you want. Does anybody live that way? I'm serious. Do you document every bottle of water you buy when you go into a 7-Eleven? Because you're asking for direct evidence of this person's buying habits every day regarding real water. That's impossible. Nobody does that.
We're not asking.
Yes, you are. Yes, you are.
So I'm unclear. Are you trying to back out of the stipulation?
I never said I signed the stipulation. I said I would put it on the record.
Joiners?
Yes,
Your Honor,
Stillwater, Tennessee joins that.
Thank you, sir.
same would be true for Hanna Instruments. I'm just going to say that if you just join.
Okay, thank you, sir.
Your Honor, and to confirm what I told counsel, we are not going to claim that she drank real water at Whole Foods, from Whole Foods.
Or UNFW?
Same thing. And so, and the reason we're not going to do that is because the evidence we have before us is that she would drink liter bottles of retail water when she was on these weekly drives. And those were supplied by Nevada Beverage, not by UNFI. So we decided not to sue Nevada Beverage in this case. The problem with their position is, first of all, I think there's incontrovertible evidence that she drank a retail bottle once a week that she got at a convenience store. Okay, can I have page 3? Mr. Hoffman showed you a couple of these already, but I think this is the one that does it, Your Honor. Top of, did I say page 3? I meant my page. Is this the op on? No, this is a wrong op. Well, maybe it is right up.
I think this is number 13. We should be on number 12.
Yeah, back up to 12, page 3, please, Chris. Okay, this is a discussion between Pat Sutherland and, first of all, there's 2 sisters, Your Honor. One's named Sutherland, one's named Ryerson. One of the sisters lived with her, which would be Judith Ryerson. Pat Sutherland is the one you've seen in court a couple times. Okay, so she's talking to Mrs. Sutherland, and she tells, they're on the drive together. They're actually on the drive together. So they stop at the convenience store. She asks her if I can get something inside. She says, yes, give me a bottle of real water. This establishes that the witness, the decedent, that was her beverage of choice, so to speak. When she went on these weekly drives, she would go in and get a real water. Now, later on, she says they couldn't find it at this particular store that day, but the very next testimony segment, Mrs. Ryerson, the other sister, says that this was her practice. Every Sunday, she'd go to Lake Mead, go to the mountains, go somewhere, stop off and buy a bottle of retail real water, okay? We don't have receipts. We don't have anything other than this testimony, but this testimony in and of itself gets you to the point where she was purchasing retail bottles of real water on a weekly basis. Now, it's true that she was, what I think we call her a heavy drinker of the 5-gallon jugs. That's all she drank. She drank these 5-gallon jugs. We're going to produce the delivery receipts. But here's the problem. Their defense in the case, Mr. Odou's defense, because he's the one that's being sued for the Ryerson case, since we don't have Nevada beverage in here. His defense in the case is she didn't drink enough retail water or real water from the 5-gallon jugs to cause her death. There was not enough hydrazine in those 5-gallon jugs to cause her death. So I'm entitled to introduce evidence of every drop of real water that she consumed. And remember, real water made the water in the 5-gallon jugs, just like they made the real water in the retail bottles. So you can't let them present this, what we call the Romeo defense of, oh, she didn't drink enough water because there's only 2 parts per billion of hydrazine, and then cut off the amount of water we get to prove that this decedent drank. So that is why this is relevant evidence, because it goes directly to their causation theory. And, you know, true, it establishes that there's hydrazine in the retail bottles, but we already know that. The testing proves that. Where is that a bad inference that causes undue prejudice to UNFI, who's not even being sued in this case? So what they want to do, Your Honor, is constrict the amount of water we can argue the decedent got. And 1 liter, you know, if there's 1 liter once a year, maybe I wouldn't feel so strongly about it. But once a week, she's drinking another liter of water, you know, on top of the 5 gallons in the retail bottles. So it's directly relevant to their particular defense because they're claiming that there's not enough hydrazine in this to cause the injury. And so that's why this is competent evidence to get into the fact that she was drinking the 1 liter bottle a week. Okay. Now they've said, oh, look at this.
I want to make sure I understand for the record, as far as her approaching history of the 5 gallons, how much was she consuming a week?
I don't know if I attached the 5-gallon records. She was drinking, I believe, 2 or 3 5-gallons a week, but I don't have it in front of me.
15 gallons a week?
She was a heavy user of, and even a heavy user of retail water, they're saying is not enough hydrazine. Even a heavy user like this, they're saying, oh, not enough hydrazine in there. So I'm entitled to introduce evidence of every drop I can get to overcome their defense. Now their argument, oh, the Southern Nevada Health District, they told them this. Well, that's impeachment, Your Honor. If they want to get up there and impeach the sisters and say, well, why didn't you say anything about the retail bottles to the Southern Nevada Health District? Fine, let them do that. But this is the testimony that once a week she went out on a Sunday drive and bought a retail bottle from a convenience store. And
Is there any other testimony on any level that she would buy other retail bottled water?
no, Your Honor. Not that I know.
Okay.
And I would expect that we would know it all because, like I already said, she lives with one of the sisters, pretty close family. You know, I don't expect there to be some other things pop up.
Your Honor, I think Mr. Kemp said 2 things that go directly to what our point is. At one point, it might have been a Freudian slip, but he said all she would drink is the 5-gallon jugs of real water, and we agree. That's all the evidence shows.
But how can we say that?
Well,
And
that's,
I don't mind saying this because, I mean, this is all speculation and conjecture. And I'll tell you why. There's uncontroverted she drinks real water. That's her water of choice. She's drinking, how many gallons is she ordering of the 5-gallon jugs per week?
I think she was ordering about 2 of the 5-gallon jugs, but I might
Okay.
be wrong. It's on the Southern Nevada Health District document if you want to pull it up.
Okay, but I mean, so you have that as a baseline.
Right.
And we have testimony that when she goes out on the weekends, she would buy real water. And so this is the assumption you're making. The only place she would get water is at home. So you can shake your head all you want, but that's why, and I don't mind saying this, that's why circumstantial evidence is really important. Because you're asking the plaintiff to, an insurmountable burden to overcome, right? We know she has preference for real water, right?
Your Honor, there is testimony that she would fill up a pitcher from her 5-gallon jugs, and I think that's how she
Well,
would
that
drink
even-
it when she's out.
But you're gonna tell me everywhere she went, she had a, what do they call it, one of those packs
Flask
on,
or, you know,
on her back?
a camelback is
A
what you're saying?
camelback, yeah.
No, the testimony I believe was that she would fill up a pitcher, or she had some sort of container, and that she
Tell me why this issue doesn't go to the jury.
Well, Your Honor, I think my other point on this from Mr. Kemp's.
I mean, really, tell me why this doesn't go to the jury. She has a history of buying real water.
So Your
That's what it is, right?
Honor, my other point on this from Mr. Kemp's argument is that it's not competent evidence. So
What do you mean it's not competent evidence?
to take it one by one. So Judith Ryerson is the one who testified that she bought the 1 per week, the 1 the one liter bottle of real water per week. That's Judith Ryerson. When she's asked how she knew that, she said Pat Sutherland, the other sister, told her. Then we deposed Pat Sutherland. Pat Sutherland said, no, it was one time. She only discussed a single time, not every week. She just discussed with her sister, Kathleen Ryerson, one single time about retail bottles of real water. And the one time Kathleen Ryerson asked Pat Sutherland to go into the convenience store.
Does anybody live that way? I'm serious. Do you document every bottle of water you buy when you go into a 7-Eleven or you go into a Walgreens or wherever you go? Do people keep track of water consumption by manufacturer everywhere she goes? We do know one thing. She had a preference for real water, right? Based upon her purchase history of the 5-gallon jugs. And so if I buy your position, she only drank water at home or she carried a 5-gallon jug with her wherever she went.
Your Honor, I don't know if we can say that based off of her preference for the 5-gallon jugs, that she automatically has a preference for retail
You can
bottles.
make that argument.
But in any event.
Can't she make that argument? I mean, what, do we have evidence of her buying Sparklets? Do we have evidence of her buying Arrowhead? Do we have evidence of her buying generic water?
We don't have evidence of her buying any retail bottles of real water, including
No.
real water or any others.
See, you're making an artificial distinction. I'm gonna tell you. It's up to the jury to decide this. And here's why. We know she likes real water, right? And so why would she go, when she's out driving home from work and she doesn't have water with her, if she goes into a 7-Eleven, what do you think she would buy?
Your Honor, from our standpoint, we believe that that is speculative and that she needs to show.
Well, you gotta have it in custom.
And that she needs to show what she purchased, but
Well, you
Your
know
Honor.
what? That's why I disagree. I'm denying the motion.
Your Honor, understood.
I'm just telling you, because,
We would ask that it's granted in the part that Mr. Kemp.
of course, if whatever
Sorry,
Mr. Kemp agrees to, as far as stipulation is concerned, that's fine.
That is.
But you're asking me to just cut and parse when we have a foundation that she has preference for real water by her buying habits and history. So, I can't say she never bought real water going into a 7-Eleven or into a Albertsons or to any store from a retail perspective, nor can I say that she did. But we do know this, she has a buying history, and that's buying real water. So it seems to me that whatever it is, it goes to the jury. Because you know what? They're not required to prove it like you want them to. This is a strict products liability case. That's what it is. And there's no question about her consumption habits, because she had a preference for real water.
So Your Honor, the only thing that I would mention, and we briefed this in the causation brief on specific causation, and this does go to the specific causation issue. She does have to show that she drank that real water in order to have been injured by it. So that goes to causation and specific causation, but we do understand Your Honor's.
Well, we'll get there. We'll get there.
So with that, I mean, obviously we would ask that it's granted in the part that Mr. Kemp
Absolutely.
stipulated,
I'm
that
not
there's gonna be no inference that this retail waters were purchased.
I'm not trying to wiggle out a step, but you don't grant a motion limiting to get where we're going. So what I will do is that I have written Mr. Neale a letter saying that we are not bringing a claim against UNFI in the real water case, okay, in this case.
Right.
I will say again on the record, and I will say that plaintiffs are not going to file a motion to conform to the ordinance or some sort.
Because you're asking for direct evidence of this person's buying habits every day regarding real water. That's impossible. Nobody does that.
We're not asking.
Yes, you are. Yes, you are. That's what you're asking. That's an insurmountable burden.
So
I don't mind saying it for the record. I really don't.
So I'm unclear, are you trying to back out of the stipulation?
I never said I'd sign the stipulation. I said I would put on the record what I'm going to do, and I think I'm bound by that.
Okay.
Signing the written stipulation, having an order on a motion when they be perverted into some sort of stipulation. I mean, I think I've been pretty charitable here.
All I'm saying is this goes to the jury. The jury will decide whether she bought retail, real water in her day-to-day activities. If she's out on a Sunday morning on a drive, she doesn't have water. I mean, because I don't see how I can grant this motion. I really don't. It's up to the jury. Because we do know one thing. She had a preference for what? Real water. It's uncontroverted based upon her buying history. Next issue.
No, I'm just gonna grab my papers on it. Oh, you're up, sorry.
Yeah, sorry about that.
Your Honor, Jim Neale on behalf of UNFW.
Sorry.
This is our motion to eliminate number 13. It is to preclude the testimony of Mr. Desitel and Ms. Converse, both of whom were testifying about conditions at the designated plant. Neither of them was employed at any time after the summer of 17. That's 4 years prior to the recall, 3 years prior to, 2 years prior to Mr. Haley's hospitalization and a year prior to Mr. Belsky's. There are 3 reasons that the court should exclude this evidence. Number 1, Your Honor, the plaintiff's theory of the case is that the hydrazine was manufactured inadvertently during the concentrate manufacture process. Neither witness had any participation in or visibility in that process. Number 2 is just the timing. We cited the La Cava case. That's a, I believe, California federal court case, Your Honor, that simply says that an employee can testify about the conditions that the employee personally observed, but that he can't testify or she can't testify about what might have happened later. And of course, the jury can't speculate that the same conditions were present 2 years after the observations of the former employee. That's especially true, Your Honor, because of reason number 3, the court should deny the motion, should grant the motion and exclude the evidence. And that's because Ms. Converse testified that she fixed the problems that she was testifying about, the OSHA violations. The court's already ruled that production issues are relevant. I won't belabor the point, but the court should exclude this evidence because neither was involved in the concentrate, the timing is off, and because Ms. Converse testified that she fixed the problem before she left in 2017, years before any of the plaintiff's water was manufactured in this case. Any questions, Your Honor?
Not at this time.
Thank you.
Your Honor, real water is drawing this motion.
In for Hanna? Your Honor, the first insurmountable evidence that the problem wasn't fixed is she left in 2016-17. We had this report in December of 2018 from NSF showing all these problems. Nothing was fixed. First point, they're arguing that witnesses that worked in 2016 and 2017 do not have relevant evidence for Mr. Belsky, who drank water in 2018. That's a 1-year time period, Your Honor. If it was 20 years, maybe that would have some merit, but 1-year time period, and if you recall, yesterday, everyone agreed that the manufacturing process did not change. It remained the same over the years.
That's incorrect.
Well, everyone but Mr. Rasmussen. Mr. Odou agreed with me, and UNFI agreed with me, so 3 people agreed. And I don't want to go through all that testimony, Your Honor, but let's take a look at what They never once say what these witnesses actually say, so in our opposition, can you pop up page 3 of the opposition? Okay. First thing he said, this is Mr. Desitel, and again, he's the, I can't remember if he's a Marine or Army, he's a former military. He testified that they didn't have an adequate procedure to document customer complaints. Okay, that's a critical HACCP deficiency. In other places where you work, when you get complaints about the products, you do some kind of investigation, yes, what do you call that? Product complaint procedure, you break it down. And even though you were allegedly the director of quality control of Real Water, you never did that at Real Water. Did not do that at all. Now, you'll see from the next motion, we have a scant number of customer complaints, about 20. But this explains why we don't have more customer complaints. You know, Mr. Neale likes to say, oh, Judge, there's no complaints about retail bottles. Well, that's pretty obvious there's no complaints about anything. They didn't have a procedure to document complaints. But that's the first part of his testimony that is relevant, and that never changed over the years. Next part of his testimony, he says, too, if he'd been told about all these complaints, and these are just the mere 20 complaints that we have. If he had been told about all these complaints, what would we have done? He would have stopped the production line. This would have been back in 2017, I believe. If he stops the production line in 2017, Mr. Belsky doesn't get acute liver failure in 2018. Mr. Haley doesn't get acute liver failure in 2019. We don't have a massive outbreak in 2020. If the quality assurance director stops the production line and reevaluates the process, this guy says if he'd been told about all these complaints, he would have stopped everything and reevaluated the process. So that is relevant for so many different reasons, Your Honor. Next thing, this is Mr. Desitel. We didn't get in, I don't know why they left the daughter's gallbladder off the second to last motion, but his daughter drank real water and she had to have her gallbladder removed, and he attributes that to real water, in addition to the dogs. But that's the next portion of testimony that's important from him. The dogs will skip. Let's go to Converse on page 6. And again, this is the one who she was actually a receptionist, and then they promoted her to be the director of quality control. So she said, first thing she said is she couldn't do her job right because they wouldn't let her into the concentrate room. That was the room where they were making the concentrate that was later mixed in with real water. She specifically says that she couldn't do her job as a quality assurance director. Nothing changed, Your Honor. After she wasn't let in that room, no one else was let in that room. The only one who got into that room was Blaine Jones. So her testimony right here that she couldn't do her job as a quality assurance director is relevant because it goes to the other time periods. It's an admission by a real water employee that there's a HACCP violation. It's an admission of a critical HACCP violation that was actually documented in the 2018 report and by others. But in any event, this directly goes to the claim against UNFI because they're contending that, oh, even if we had sent someone in to do an inspection, we wouldn't have found anything. Well, they locked all the inspectors out of this room too. So this testimony is relevant for that reason. Next one. Where are we at here? What page you on, Chris? Okay, 7, you're ahead of me. Let's go back to 6, please. Go back to the bottom of 6. This is her testimony that she had no HACCP background whatsoever. She didn't even know what HACCP is. And she's the director of quality control. Didn't even know the first step in the HACCP process. And there's no dispute that HACCP training is necessary for a quality control position. And another reason this is relevant is, remember, UNFI started supplying real water in 2012. They supplied it during the exact same time period she was the quality control director. If they would have been going in and doing the third-party audits like they should have, they would have found out what she says. She didn't know about HACCP, couldn't go into rooms, and that's why it's an important piece of testimony. The next piece of testimony they want to keep out is the bottom of 6, please. Yeah, there we go. Yeah, good. So she testifies that on every shift, every single shift, they weren't doing proper meter readings. We think that goes to the proximate causation case. Next one, 7. This is on the ORT meters. She's talking about the ORT meters, and she says that they were never calibrated right. Well, of course they were calibrated right because no one told them to dip it in vinegar for 5 days. But she explicitly says, the quality control agent, that they weren't calibrated, they weren't working, and so the solution is they would order more ORT meters. And they ultimately wound up buying 90 ORT meters from these people over the course of about 5 or 6 years, which is an astounding number of ORT meters when you consider that they're supposed to work for a year or two. So they just kept buying more and more ORT meters. But anyway, her testimony is relevant because she shows that the autometers weren't working. Next one. This is a good one. So NSF came in and did a third-party audit in 2016. I didn't show Your Honor that one, I showed the 2018. She testifies that someone forged her signature on this audit. This is the prior one. She said that she was supposed to sign off as the Director of Quality Control. Someone at Real Water forged her signature. Can we have the next page, please? I think we did that. Yeah. Right here. Last page of the NSF audit. That is not your signature, you tell me? It does not look like your signature. And then she describes why it is her signature. She doesn't do that. Okay, the only possible explanation for forging the signature of the Quality Assurance Director on an NSF audit is you're trying to keep it hidden from somebody. You know, for some reason, you aren't showing your own Quality Assurance Director the third-party audit that discusses quality assurance problems. Instead, you forged her signature on it. I mean, that is just such a damning thing, Your Honor, that to suggest it's not relevant because this happened in 2016 and Mr. Belsky drank the water in 2018. Next one. This is Ms. Converse's testimony that, you know, I can't make this stuff up. This is her testimony that she, the Quality Assurance Director, didn't get the customer complaints because they sent them to the sales team, okay? If you remember, Mr. Desitel was the alleged Quality Assurance Director right before her. He didn't get the customer complaints either. Never saw them, said if he'd seen them, he would have stopped the line. So here's the second quality assurance person in a row. Actually, she's before Mr. Desitel. She says she never saw them. You're the Director of Quality Assurance, right? And who else would be responsible for that? They went to Amy, that's Amy Jones, Brent Jones's wife, and the salespeople. So they gave them to the salespeople. Probably gave them to the salespeople because the solution was to give people free water. It wasn't to investigate the complaints. But this testimony is directly relevant, Your Honor, because here we have the Quality Assurance Director in 2017, the next one in 2017. They aren't even seeing the customer, they're not even seeing these complaints, much less do an investigation, which Mr. Desitel said would have resulted in him stopping the production line. Okay, the next statement. She confirms, this is Mr. Gelman. He had a pretty interesting customer complaint that I think we're going to get into on the next motion. But so I showed all these customer complaints to her, ones that came in at the time period that she was supposedly, or that she was the Quality Control Director. She's seen the Gelman one, okay? The solution to Mr. Gelman's complaint was to give him more water, and that's what Mr. Jones told her to do. But they didn't investigate it. So rather than investigate it, they gave him more water. Another HACCP violation, Your Honor. You're supposed to investigate customer complaints. So, I mean, I could go on and on for Mrs. Converse's and Desitel's testimony, why they're relevant. But this is why this testimony is all relevant. It happened a year or 2 years before Belsky. You know, I just don't think there's any basis to argue that it should be excluded, Your Honor. And for those reasons, we oppose motion. Let me check my notes, make sure I've got. No, Your Honor, that's it.
Your Honor, I'm sorry to stand.
Oh, no, you can stand.
And I need to correct what Mr. Kemp said, because he keeps using the word calibration. And that's not correct. And it's on a document that I can show him, he's already seen it, that they basically sued us because of this instruction, but he still hasn't got it right. So this is more like trying.
And take your time, sir, and walk back to the microphone.
Well, this is the instruction manual.
Your Honor, I think the quick answer to Mr. Rasmussen's concern is that all the lay witnesses are using calibration and oxidation interchangeably. I recognize that there is a technical difference between the two. I know what it is, but the testimony is referring to the process of oxidization. That's pretty clear.
To be more clear, and I appreciate, well, do you have any problem with me showing this to the court?
No, go ahead.
Okay. Does anyone over here? I don't think so. All right, I'm gonna show you. From plaintiff's production of documents, 4484, it's a date stamp there at the bottom. And I'm gonna be looking over here in the far right corner on this instruction, okay? So she picks out a piece of testimony from Ms. Converse that has something to say about calibration and that we never got it calibrated correctly. Okay. That can't be true because the ORP meters are factory calibrated. They're never calibrated by the users. There are three, I'm going to use the word C, because they all start with C, and it'll help to explain to the court what's going to happen during this trial. The first C stands for cleaning. Cleaning is cleaning the probe, the tip of the probe, so that it's clean and can continue to read things, do meters readings on stuff. There's substantial evidence in the record that this was not being done by real water. Number two is calibration, which you're looking at right now. That's never done by the users. Now, if you have a combination probe or ORP meter that's also got a pH part of it, then you calibrate the pH side. And I talked yesterday about the fact that real water had a meter that had both of these, but it was a pinpoint meter, not ours. The last one is called conditioning, so I got 3 C's. Cleaning, calibration, conditioning. Conditioning is only of the probe, and that is done through vinegar or an oxidation kit. And last week, when I stood up here, I showed you the kit that they have. And when I mean they, I mean real water had. They had purchased it. It was what we found when we went out there to look at their facility. And when we were there, we found the oxidation kit. It's reusable, which means you can use it on this probe, the next probe, the next, as many probes as you like, so long as that water doesn't run out, or the solutions don't run out that's in the oxidation kit. And what the evidence shows is that there were still solutions in those oxidation kits, which means they were still using them up to the time that they shut down in 2020. My point, and the reason I stood up here to begin, is that calibration, when she talks about it, remember, she's the quality control person. And it's going, we were always having problems with calibration. Well, if you had someone that was qualified, you know that you can't even use the word calibration because you can't calibrate these meters because they were factory calibrated. Not true with a pinpoint ORP meter. That particular meter, not my company, Pinpoint is the brand name for that, is calibrated or available for calibration by a user. Big difference. And we'll have the evidence to show why that makes a difference in this case. But ours specifically says nothing about calibration can be done by the user. So I only get up here to correct that record to make sure that when you're going to introduce evidence and insinuate that has to do with my meter, that can't be true because they're factory calibrated. That can be true for the pinpoint one. That pinpoint's not in this case, and I think that would be very prejudicial to talk about a meter that you can't do calibration for. And that's my own reason for being up here, Your Honor. So I want to make sure that it's on the record so that when you hand down your ruling on this, that particular piece of evidence is not a part of the discussion in your order. Thank you.
And I want to make sure I'm clear, sir, because it seems to me the thrust of the motion dealt with defendant's course of conduct and business practices. right?
Yeah.
And so from your perspective and with your client, they don't necessarily come under that because that's a slightly different conduct, right? Slightly different.
Not even slightly different. You can't do what Pat Converse says you can do to our meter.
Understand?
Calibration, if she's gonna use that word, now, she could get the words wrong. I'll concede that he can say, Pat Converse was wrong when she testified this way. I can't stop him from doing that, that wouldn't be fair. But to suggest that my meter can be calibrated by a user can never happen. It is, as I've showed you right there in that document, factory calibrated.
Understand?
And then in the document that I showed you yesterday, when they said all of the different testing that we did for all the different kinds of water, including Dasani, real water, Kangen, Aquafina, all these different people, the meter that was using was a combination PHORP meter manufactured by Pinpoint. And on that particular style of meter, you can, as a user, calibrate it. So if she's having a problem with calibration and she's right in what she's saying, the questions that were just put in there had nothing to do with my meter. Thank you, Your Honor. Sorry to take the time.
No, that's fine, sir. Thank you, sir.
Sorry about that, Jim.
You're fine.
And reply.
Thank you, Your Honor. In reply, I'll simply say this. Mr. Kemp's argument was that these observations are relevant because they may demonstrate deficiencies in the production process that approximately cause the alleged defects in the product that the plaintiffs consumed. The problem with that statement, Your Honor, while I agree with it in the abstract, is that these observations can't possibly detail production problems that approximately cause defects in the water that these consumers drank because they occurred years prior to the bottling of the water that these consumers drank. We have the testimony of Michael Bush. We have the testimony of Tom Pham. They were the directors of quality control at the relevant times, and whatever they saw, good, bad, or indifferent, is the relevant evidence that goes to proximate cause. That's why the court should grant this motion.
Thank you, sir. And what I'm going to do is this, regarding the motion, it will be denied. I think when you look at it from a timing perspective, defendant's course of conduct and also business practices are relevant as it relates to their production activities. And this isn't like it was 10 years or 20 years before. This is still within the relevant time period. Just as important too, these are witnesses' testimony that worked there. And at the end of the day, I'm going to let the jury decide that. They can believe the witnesses that testify at the time, or I don't know the time this event occurred, but also the testimony as far as course of conduct and business practices will come in. Okay, let's move to the next one. And that's number.
Next one is
Yes. I think after this one, maybe take a break.
This one, there's a lot of, we're gonna go through, it might make sense to do a break before if you want.
Okay, let's take a break.
All right.
All right.
Please be seated.
Yeah, thank you, ma'am. And where did we leave off? Number 14, right?
Yes, Your Honor. All right, Nicholas Hoffman for UNFW. Next up is UNFW's motion eliminated, number 14. This is our motion to exclude evidence of unrelated consumer complaints. And so, I obviously want to give the court the disclaimer that some of this material has been covered. This is a relatively lengthy motion because it covers a lot of exhibits. So this one essentially has to do with, primarily with, the consumer complaints that Real Water received for non-conformances, foreign objects, things like this that occurred during the manufacturing process dating back at least until 2013, I think was one of the earliest ones that I saw. These were produced by Real Water during the litigation, and they were relied upon by plaintiff's counsel during various depositions. So I will go as quick as I can. I do need to
Take your time.
Okay, I do need to show the court, obviously, each of these complaints, explain why we don't feel that they are substantially similar, or why, there are issues with them. But to the extent I'm going too quick, please just let me know. So, to put this in perspective, Your Honor, as Mr. Neale has pointed out to the court, there's evidence in the case from Brent Jones that Real Water was manufacturing and selling over 10 million bottles of retail Real Water per year. So 10 million bottles. They've produced in this discovery a small handful. I think we have about 20 that we're going to show Your Honor now.
Yeah, I think it's 20.
Of non-conformances. Foreign objects, things like this. Or there are some where people say, they had diarrhea and whatnot. And we spoke yesterday about Dasani, for instance, and, I think for any big bottled manufacturing plant, Dasani, no matter who it is, Real Water, unfortunately, there are non-conformances, that's part of the territory. We do think it's important to assess each one of these for substantial similarity, for, the hearsay issues, to see why plaintiffs, and we'll show the evidence of how they're trying to use them, to see that purpose. And unfortunately, and this is why this motion is important in our minds, plaintiffs have confirmed that they intend to introduce all of the consumer complaints that Real Water ever received, and all negative testimony about Real Water, regardless of the facts, circumstances, or causes of those other events. So, as far as we can tell, Mr. Kemp at trial and plaintiffs intend to introduce every single consumer complaint that ever was created for Real Water. Now, I will try to go as quick as I can. The public policy behind this substantial similarity analysis is because, and I think a car is an easy example. If you're driving a car and you go off the road and crash and it's a alleged wheel failure, you sue the car manufacturer and you sue them and you allege that there was a flawed wheel. You don't get to then at trial introduce an adverse event involving, for example, a smoking engine or a non-conforming engine, because you are not alleging that type of defect. So, what becomes relevant for the jury to see, and what the jury could potentially infer causation based off of, would be a substantially similar event involving what's alleged by the plaintiff. So there would be this, wheel failure, and if the accident happened in some substantially similar circumstances and whatnot. If the plaintiff tried to attempt to introduce all adverse events to paint the picture of a bad car, and shoddy workmanship, and that this is just a bad manufacturing car company, that's obviously unduly prejudicial based off of Nevada law and the broader substantial similarity case law, and does not go to the question of whether there was an alleged defect in the case that actually caused the plaintiff's injuries. For the notice consideration, obviously a prior incident involving a smoking engine or some non-conforming engine, as an example, does not put the manufacturer on notice of any defect with the wheel. So it wouldn't put the manufacturer on notice of that issue that the plaintiff is actually suing over. So I use that example because I think it's a little bit easier, to understand, but the same exact principles apply in this case. So for these complaints, these consumer complaints to be relevant, there has to be substantial similarity to the allegations made by plaintiffs in this case. If these other consumer complaints have to do with an issue that plaintiffs are not alleging, they are not relevant here, and in fact they would be unduly prejudicial, because what they try to do is they try to paint this picture of Real Water being a bad company. And there's plenty of evidence that they can try to use about other issues in the plant and whatnot, but the law is clear that for these types of other incident evidence, you do not get to introduce it unless there is substantial similarity. So, I think that's the key consideration. Here, as I've said, plaintiffs are trying to introduce over 20 additional consumer complaints, or I think it's 20 plus some testimony, without making the foundational showing of substantial similarity with the facts of this case. They want the jury to infer that because of the presence of those other complaints, even if they are factually different, that a defect existed which contributed to plaintiff's injuries. And essentially what they're doing is trying to show that this is such a bad situation based off these other incidents, even if they're unrelated, that the jury can infer causation because Real Water is such a bad company and had such bad practices, and the law is clear that you can't do that. That violates the substantial similarity analysis under Andrews and Guinness. Your Honor, I think it also brings in significant due process considerations if any punitive damages are allowed, for instance, against Real Water. The conduct that is at issue is what happened in relation to these plaintiffs that are before the court. So with that intro, I would like now to take a few moments and show the court briefly each of these written consumer complaints that we are seeking to exclude. So the first one, and I'm going to have Mr. Stevens switch over. This is attached to our motion limine. It was introduced by Mr. Kemp as Exhibit 20A at the deposition of Mr. Desotel. This is on page 72 of our motion. So this one, and it's small, it's a 2013 complaint. It's from an individual named Juan, and he reported to Real Water that he had purchased Real Water from Joe's Downtown Market. And he says that he found dirt, particles, or dust in water that he consumed and made him sick. He said he went to the hospital, in parentheses, wasn't very happy. That's filled out by a Real Water employee in 2013. That's about as much information as we have about that one. We don't have any, allegations of liver injuries or other information that we have. And obviously, we'll get to this, but we also think that this is remote and in time, and it is, under the Nevada case law, it is a temporary condition. I mean, there's no evidence of any dirt or dust particles in any other water of Real Water throughout the time period, throughout its history, as far as we're aware. And there certainly is no allegation of dirt particles or dust in the water for any of these plaintiffs. And we will show you the testimony of Mr. Haley and Mr. Belsky in this case, and they do confirm that. So that's the first one, Your Honor. With that, and as I said, if I'm going too quickly, just let me know.
No, take it.
So the next one is on page 77 of our motion, and that is Desotel Exhibit 20B. And this one is a letter from Argo Insurance, and it's basically reporting that the insurance company's insured operates Mother's Market located in Costa Mesa, California. And it says that around July 27, 2013, a customer reported becoming ill after drinking a bottle of Real Water. She indicated that there was an oily red substance inside the bottle. And then it says, although Ms. Brooks indicated that she became ill, I am unaware of any actual medical treatment she may have sought. And Your Honor, we don't have any other information about this alleged consumer complaint other than what's been provided in this exhibit. Obviously, I would note, and I'll go through this again at the end, we have no other complaints about an oily red substance being in any of the retail bottles of Real Water. I believe that this is the only one, as far as I can tell. Again, this is obviously a temporary condition under El Dorado, which is a Nevada Supreme Court case and other case law. We don't think that this is any sort of permanency or showing that's relevant here, particularly because plaintiffs themselves have never alleged that there is any oily red substance in any of the Real Water that they drink, and we'll show you that testimony here in a bit. The next one is on page 78 of our motion. This is Desotel Exhibit 20C. This is the third consumer complaint, if you're counting, that I want to show the court. So this one the top data is a little scribbled. I think that they made a mistake and said 13 at the beginning maybe, but on the bottom right, you can see that this is from April 2nd, 2014. This is a customer who emailed and said that there appeared to be in the bottle the preform resin or oil from the manufacturing process. And it says the customer was given a free case of water. So the preform resin, Your Honor, has to do with the bottles. They are blown to form them, and they come, I believe, in these little plastic preforms. And apparently, my understanding of what this is saying is that preform resin for the bottles as they were blown somehow ended up in the retail bottle of Real Water once it was finished. Again, we don't have evidence of any of these plaintiffs having this issue. We have no evidence here of this person becoming ill or having any sort of issues with this. The next one, which is number 4, that I want to show, Your Honor, is on page 80 of our motion limine. And when I give these page numbers, by the way, just so the record's clear, I'm giving these to our tech guy who's in here, and these are actually referring to, in the PDF of our motion limine, what it would be in the PDF. So this one is page 80, and in the motion limine, it's attached as Desotel Exhibit 20D. So, Your Honor, this one is another 2014 customer alert form that Real Water produced. And this one reports that this individual purchased the Real Water from Chevron in Las Vegas in 2014, and there was a strong chemical smell in the bottle, and that he did a TDS rating, which is the total dissolved solids, I believe, and he found a certain TDS rating. Now, Real Water, I'm not going to get into the manufacturing process. I'll let Mr. Kemp or Mr. Rasmussen get into that. But my understanding is there is a target for the TDS and whatnot. And he went on and he purchased several other bottles from the gas station and in that area with the same manufacturing, all of which tested around 19 TDS and smelled fine. It is inconclusive if the customer complaint was legitimate or not. This issue is considered closed. So again, Your Honor, we think that this shows this is kind of a one-off non-conformance, or, even if, I think there's one more that's kind of like this from the same guy. This is certainly not a problem that's been alleged in this case by plaintiffs. There is no allegation in this case that it had a strong chemical smell for any of the water they drank, and they were asked, and we will show Your Honor that testimony. The next one I want to show the court is on page 81 of our motion limine, and that is Desotel Exhibit 20E. So this next one, my understanding is that this is the same guy. He says he bought it from Chevron, and he found a gasoline-like substance in a blue liter bottle purchased at Chevron at the same Chevron store. It says a similar report happened a few weeks prior from Chevron on St. Rose and Spencer. I guess it was one slightly different Chevron, also in St. Rose, but a different Chevron. Then it says customer's mom dropped off the bottle. It has the manufacturing date. And then it says that this Real Water individual went to both Chevrons and bought some bottles, including one from the same manufacturing date. Store personnel said no problems about water taste here had been reported. We tested the pH, ORP, and TDS. That's the total dissolved solid. On the store-bought bottles and control bottles from the date of manufacturing, there were no problems indicating a gasoline-like substance in any of the bottles. The results are once again inconclusive, like in the report a few weeks ago. Customer's mom was given a free case of water when she dropped the bottle off. We are considering the matter closed. Again, we have no evidence that this individual was ever sick, had any sort of issues whatsoever. They reported that there was some sort of weird smell with the retail bottle of Real Water. And again, like the one that I just discussed, which was Desotel Exhibit 20D, there's no evidence here that any of the plaintiffs in this case had any sort of issues with the gasoline-like smell or substance in any of their bottles. They all said that there were no such issues. The next one up, which is number 6 that I'm going to show the court, is on page 83 of the motion. This is Desotel Exhibit 20F. This one is a 2014 complaint, and it had, quote, a slight candy / soda-like scent and a cloud substance in the bottle. And then I'll give you a second to review it, but then if we could go to page 86 of this, which is the continued complaint. There, and I know it's black and white and it's a little blurry, but there is supposedly the cloudy substance that was in the bottle. Now again, there's no injury alleged here, there's no liver failure, there's no issues. For these plaintiffs in the case before your honor, there are no allegations of any slight candy / soda-like scent or any cloudy substance in any of the bottles consumed by the individuals in this case. The next one up, which is number 7, is on page 88 of the motion. This is Desitel Exhibit 20G. Your Honor, this is a 2014 complaint, and this says it has pieces of styrofoam, quote unquote, that were in the bottle, and that it, quote, smells like lemon juice, end quote. Your Honor, to be clear, as I've said, there are no allegations in this case of any styrofoam or foreign objects in any of the retail bottles that were consumed. And there were no allegations that any of the retail bottles smelled like lemon juice. On this same complaint, on the next page, page 89 of our motion, it explains that this was purchased at Nob Hill in Gilroy, California. That's where this specific bottle was found. Next up, we get to what I understand to be a complaint relating to Susan Doran, who we also have Mr. Kemp took her deposition testimony. We'll get to that. This is on page 90 of our motion. This is Desitel Exhibit 20I. It's a 2016 complaint. And John, if you would go to page 92, this shows the actual email that I understand Ms. Doran sent. I believe she sent it under the name Lime Ginger. This was December 1st, 2016. She says a problem with the water. And on this one, this is the first one where she says that she had a burning, sour feeling in my gut, and as I said, diarrhea. It is not anything else because nothing in my pets or my diet has changed. I think you need to look into what the problem is. I will stop buying your water in the meantime. My guess is this. You are using water from the Vegas Valley and it is hard water, which my whole life has given me diarrhea. Otherwise, something you are treating the water with or doing to it is making me sick or the bottling is unsanitary. And Your Honor, I don't know as much, admittedly, as perhaps Mr. Rasmussen or perhaps Mr. Kemp about the manufacturing process, but I do know that Real Water was taking water from the Vegas Valley and they were using municipal water. And so I don't think that she's wrong in that regard, although I invite other counsel to correct me if I am. So I do think that Real Water was using hard water, and we'll get to it here in a bit. She'll explain in her deposition that essentially this is an issue she had her whole life whenever she did drink hard water. The next one is on page 93 of our motion, and this is, again, from the same individual, Susan Doran. This is Desitel Exhibit 20J. It appears that this is related. This, I think, is multiple forms that are filled out for Real Water. The next one is Desitel Exhibit 20K, and that's on page 94 of the motion. So, Your Honor, this one is a 2016 complaint from an individual named Howard West. This one says it was from the Real Water Tennessee plant. It was purchased through Real Water's website. And it says there was a difference in the taste of the water that was extremely noticeable. There is, as you can tell, no alleged injury, no, allegations of liver failure or anything like that. All that we know is that there was allegedly a difference in the taste of the water. and we'll show the testimony here in a minute, there are no allegations in this case of any off taste or, difference in taste for any of the retail bottles that were consumed by the plaintiffs in this case. The next one up is Decitel Exhibit 20L. That is page 95 of the motion. So this one's a 2017 complaint, and I've been trying to go in kind of chronological order here so that Your Honor, can pay attention to the remoteness of time, and we finally have reached 2017. All those ones that we've gone over before are from earlier dates, dating back to 2013. I do think that there's a couple of early ones at the end that for some reason were attached later, but we now have just reached 2017 in terms of the timing. This one is from an individual named Jason Eaton. He reports that he purchased the 5-gallon jugs from Silver Springs, which is apparently a company that had some sort of affiliation with Real Water here in Vegas around this time period. He said that he'd been researching the water for about a year, and he had been testing the 5-gallon jugs of water. And in his own testing, he tested it with hydrogen peroxide test strips, and he said that he found about 5 million hydrogen peroxide, quote unquote. Says about 100 parts per million of hydrogen peroxide. And to be clear, I do have a biochemistry degree, but this even to me is a little bit, I can say that this is not hydrazine, I know that for sure. And there is no allegation in this case of any hydrogen peroxide being found in any of the plaintiff's bottles of water. This is a completely separate thing, and I would just note also that, there is no injury alleged here. This is a guy saying that basically he's been researching the water for a year. He seems to be some, perhaps hobbyist, I don't know, but he says he's testing it and he found hydrogen peroxide. The next one up is page 96 of the motion. That's Decitel Exhibit 20M. And that's a 2017 complaint. This individual named Sam Gelman purchased from a gas station a gallon bottle, and the water, quote, smelled foul and tasted like chemicals, end quote. And then Sam wanted to inquire about his options on replacing the bottle he purchased. There was no alleged injury here, Your Honor. There's no evidence of anything relating to this individual, no evidence of any liver failure or anything like that. On page 97 of this, so the next page, John, we have some communications back and forth between Patty Converse and this individual, Sam Gelman. And it appears to me that this individual, you keep going down, John? Here we go. So on February 6, 2017, when Patty Converse says that she'll give him, free bottles of water for, the inconvenience he had and the bad water they received, says, that would be amazing. I really appreciate your quick response. It gives me confidence that I'm buying the best still. My address is, and he gives the address. And this is a consistent theme with these consumer complaints. We've put them all in our motion. I'm trying to spare the court some time and get us out of here at a reasonable hour tonight. But these consumer complaints do have other documents with them, and pretty consistently, I obviously can't say it for all of them, but there are a lot of instances in the documents we've presented to the court where Real Water gives the individual some water, when they have a complaint. They then take that water, and then we have evidence that everything was back to normal. All the water was good. The consumer says that the water was good. So we're going to get to one in a second. Lois Kessler, she's deposed. She complains about the taste, and then she's given the free water from Real Water, and then she says everything tasted normal. Going forward. So these are kind of temporary, one-off instances of non-conformances as far as we can tell. The next one up is page 99 of the motion. This is Decitel Exhibit 20N. This one, again, is that same individual we've now seen 2 times before. That's Susan Doran. She's going to be, we're going to show her testimony as well. She's Lime Ginger, and she reports again on page 100, John, of this exhibit, Exhibit 20N to the Decitel deposition, that, again, she had diarrhea, and again, she says that she suspects it's because they're using water from the Vegas Valley taps and simply making it taste better. But it is hard water, which my whole life has given me diarrhea. Otherwise, something you are treating the water with or doing is making it 2 pets, 1 kid, 1 middle-aged woman, me, and 2 fragile older people sick, or your bottling is unsanitary. That's Mr. Orion. Next one up, number 14, is Desitel Exhibit 20-0. This is page 104 of the motion. This is a 2019 consumer complaint. And this individual, Stephanie Poole, in 2017 said that she purchased this at Costco's Business Center on MLK. Obviously, Costco's not in this litigation. Her complaint was that the water she purchased from Costco had a bitter aftertaste for the case she purchased, and then she went back and purchased another case, but there was no bitter aftertaste. So only the bottles from February, I think it says 10th, 2019 had an aftertaste. Your Honor, so this is another example of an individual who has no alleged injury, certainly no alleged liver failure or liver issues. She reports a bitter aftertaste. Again, as I'm going to show the court, there are no plaintiffs in this case who have alleged any sort of bitter aftertaste for any of the bottles that they had. And then, this is another example of an individual who says that they had, this issue for 1 bottle, then they go get other bottles and they no longer have this issue. Your Honor, next up is Desitel Exhibit 20P. This is page 105 of the motion. This one is a 2017 complaint, and I apologize, I think this is where we did a little bit out of chronological order. So this one is 2017, it's from a customer named Mary. She reports that she purchased in, I think it says Corvallis, Oregon, from a market of choice for Winco in Oregon, 2 bottles that had a fishy smell and taste. She says it burned her throat for a whole day. Her stomach had been upset and gurgling since she drank the water, and she also had black tarry stools. So again, Your Honor, we'll show the court here in a few moments. There are no plaintiffs in this case that allege that they had any water with a fishy smell. There are no plaintiffs in this case that allege that they had any water that had that burned their throat or had a fishy taste, as she says. In fact, the 2 individuals, as we'll show the court, Mr. Haley and Mr. Belsky, alleged that they actually did not have any symptoms at all until several months after consuming the retail bottles of Red. The next one up, Your Honor, is Desitel Exhibit 20Q. That's page 106 of the motion. This one, Your Honor, the individual reports, this is Connie Willis, reports that she went and drank a lot of real water and that she believes she has hyponatremia, which is consuming too much water too quickly. And she sends to Real Water this kind of, I don't know where it's from, but it looks to me like what I'll label colloquially as a WebMD printout. And she says that essentially she believes that she drank too much water. She was having cramping, nausea, vomiting, and diarrhea, along with feeling extremely hot and head achy. And then she says that they should educate people to drink only a little at the start or it's diluted. Your Honor, so again, this is an example of an individual who had immediate illness. That is not alleged by these plaintiffs in this case. Mr. Haley, Mr. Belsky will play their testimony here in a few moments. Also, there are no allegations here of liver failure or issues like that. Next up, we have Desitel Exhibit 20R. This is page 107 of the motion. This again is a 2017 complaint. This is from an individual named Robert Fisher. I think we'll find out here in a few moments that this is in relation to Trey Fisher, who was deposed by plaintiffs in this case. And Trey Fisher purchased some real water from Sprouts in Tampa Bay, Florida. And then we're going to go on to page 108, John, if you don't mind. So Trey Fisher reports that he purchased the real water in Tampa Bay, Florida. He drank 1.5 gallons of it within 6 to 8 hour period. And then he started to feel sick that night and woke up in the morning with quite severe symptoms of confusion, hand tremors, nausea, and vomiting. He went to a clinic, and the doctor said due to the large amount of alkalinized water, essentially the 1.5 gallons he drank within a 6 to 8 hour period, it caused him to go into a state of metabolic alkalosis, which essentially is drinking too much alkaline water. So it's, you're essentially destroying the acidity in your stomach and whatnot. And we will show the court his deposition testimony. Next up, and we're reaching the end at least of the written paper complaints. This is number 18. This is page 114 of our motion, and it's Desitel Exhibit 20T. This one is from an individual named Samuel Russell, who sent this in November 11, 2020. Said he wanted to cancel his service, and he wanted Real Water to pick up 3 still full water jugs and an empty one. And he said that the cleaning process is absolutely horrible and had made his entire family sick. He said he had run his own tests on the water, and there was bacteria in the water, and that is truly gross and inexcusable. And he asked to have Carlos pick up the jugs on Friday, and he expected a full refund on the jugs that weren't used. And so, Your Honor, I mean, I would point out on this one, there is no allegation of plaintiffs here of bacteria. In fact, they hotly contest. They claim that there was no bacteria in the 5-gallon jugs. This is also obviously after the purchases by Belsky and Haley, which are the purchases in relation to my client, UNFW. So next up, we have Exhibit 20U of the Desitel deposition, and it's attached as page 115 of our motion. This one, as far as I can tell, the only information we have is that subject line up top. It says water makes them sick. And it seems, and I'm not aware of us ever getting a hold of the voicemail. I don't know if plaintiffs, they'll correct me if I'm wrong, but I think for this one, we literally just have this email with the information up top that says water makes them sick. I don't think we have any other information. Next up is Desitel Exhibit 20B. This one is page 116 of the motion. And this one is another 2014 complaint, and I think it might be duplicative. I think it might reference one of the prior complaints, if possible. But essentially, this is from an individual who, and John, if you go to page 118 of this one. It's an individual who is saying that he had that cloudy foreign object in there and that he didn't know what it was, and he was asking for more information from Real Water about what the cloudy object was. So next up, Your Honor, this motion also, in addition to the written consumer complaints that we just went through, so the 20 consumer complaints, this also relates to the deposition testimony of the consumers. So, Mr. Kemp, for a number of those that we just saw, deposed the individuals, and we have made short clips of testimony for each of these individuals that we would like to play, and it will be a combination of clips, and it follows exactly the testimony that we cite in our fact section of the motion. I'm happy to read the page lines if you guys want. So the first one up is going to be Trey Fisher, and Trey Fisher, Your Honor, he was deposed in this case. He alleges that shortly after drinking Real Water that he purchased from Whole Foods, he experienced confusion, or I think it's Sprouts, purchased, I guess we'll watch, but experienced confusion, hand tremors, nausea, vomiting. He went to the doctor, and the doctor told him that he was in metabolic alkalosis. He had drank 1.5 gallons in 6 to 8 hours, and he never, I think this is the key part from our standpoint, he never had any liver problems or liver failure, never diagnosed with it. So with that, I'll let Mr. Stevens play that report.
Starting at that, I started to feel sick that night. I woke up in the morning with quite severe symptoms of confusion, hand tremors, nausea, and vomiting. I don't recall within an hour, but that same day that I drank it, I recall feeling sick. Yeah, so it's like a walk-in clinic. It wasn't part of an actual large hospital.
Okay, is that like an urgent care?
Yeah, it's like an urgent care.
Okay, and so when you went to the urgent care, were you treated?
In short, no. I saw a doctor. I told him what my symptoms were, and his best guess was the metabolic alkalosis.
Okay. And you've never been diagnosed with any liver problems or liver failure, right?
No.
How about any kidney issues?
No.
Have you had any gastroenterology issues?
No.
All right, so that's Mr. Fisher. He is also in relation to the Decetel Exhibit 20R that I previously showed the court. Next up is an individual named Susan Doran. She is Lyme Ginger. She's in relation to 3 of those prior consumer complaints that I read to the court. Those are Decetel Exhibit 20I, Decetel Exhibit 20J, and Decetel Exhibit 20N. Ms. Doran says that she experienced a raw burning sensation after drinking real water and diarrhea. That was in 2016 or 2017. She believed it was from real water using hard water during the manufacturing process, and Ms. Doran does not claim to have any liver injury from drinking real water. So with that, Mr. Stevens, if you could play Ms. Doran's clips.
Did you get diarrhea?
Yes,
How about your parents
yeah,
and the cats?
yeah.
Did anyone vomit?
No,
In the email you say, quote, "It creates a burning, sour stomach," unquote. Do you see that?
mm-hmm,
Yes?
yes, I see that.
Okay, what do you mean by that? What did you mean by that?
It felt, and I am just gonna ask you a question. I also did send an email similar to this, mentioning these symptoms in November of 2016, but I presume you're gonna come back to that. So I'll stick with what you've asked me here. It was like a raw burning sensation.
Back when you alleged you were sick due to drinking real water, did you seek any medical treatment?
No,
In your March 3rd, 2017 email, you mentioned that hard water had given you diarrhea your whole life.
mm-hmm. Yes,
When did you first experience diarrhea that you attribute to hard water?
um, 1970.
So that's Susan Doran. Says that she's had these symptoms from drinking hard water dating back to 1970, but is in this case suggesting that it might relate to real water. Next up is Lois Kessler. She's another individual that plaintiffs deposed in this case. Towards the end of 2015, she drank real water that, quote, tasted very bitter. She now has learned that she has fatty liver disease several years later, but never had liver failure, and I don't believe has any diagnosis that the fatty liver disease is connected in any way to the real water. So with that, I'll have Mr. Stevens play that for the court.
It must have been at the very end of, very end of 2015 when this occurred.
And you said the problem was it tasted awful, I think the word you used.
Yeah, it tasted very bitter.
And what was the name of the store that you were purchasing the real water from?
Well, there was 2 stores I used to purchase it from, Bristol Farms and Sprouts.
And Bristol Farms is what kind of store?
It's a grocery store, more of a specialty grocery store.
And when you read this, you saw, and I think I heard you perk up when you read, "She has left a message at the Tennessee office." You see that there?
That's, well, I see that, yeah, I have a copy of this, they sent this to me here, I'm looking at it.
Yeah.
She has left a message at the Tennessee office, so I guess, yeah, this is how long ago, 2016, so that was, what, 7 years ago. So, you know, if it says I left a message at the Tennessee office, then that's where I must have left a message.
Right, and the reason, you said earlier, ma'am, that you looked at the bottle and you called the entity that was listed on the bottle, correct?
I think that's what I did, unless Bristol Farms gave me the number of who to call. It was
Right.
7 years ago. I did call somebody, either I got it off the bottle or the box, the case that I bought, but there was a number I found, and I called them and said, something tastes bad with this water.
Yes, ma'am. And I'm showing you now the backside of a picture of a 1 liter bottle of real water.
Yes,
And do you see on there, ma'am, how it lists a Tennessee address for CJR Bottling LLC?
let's see. Bottle, I don't see an address. So it's, oh, yeah, Tennessee tea. Yeah, I see that, yeah, Tennessee, yes. There's no phone number.
No, there's not. Can you think of anywhere else you would have gotten the contact information for the company to call in Tennessee?
Maybe I just looked it up online.
Yeah.
I could have looked it up and maybe that was listed as their main office. I know how to use, Google and all that.
course.
I could have put in affinity drinking water, real water, and like I said, or I could have gone back to Bristol Farms and they told me who contact, or maybe they got the number from the representative, I don't know. There's a phone number I'm saying for, let's see, what's it say? Call 877, what's that number above that? I can't read it. It's,
Yeah, 254-9290.
yeah, what number is that?
Well, I think that's a number for real water. And in
Maybe
any
that's what it's
event,
called.
yeah, okay, very good.
Yes, I do. I have fatty liver now, but I don't know, what it's from. I had fatty liver that developed.
Were you ever diagnosed with liver failure?
No, just my liver enzymes went up. They didn't know why. And, no, I never had liver failure. I just went up and they diagnosed me with a fatty liver.
Yes, ma'am. And were you ever diagnosed with acute non-viral hepatitis?
No.
And I apologize, that one went a little longer than I expected. But as you heard there, and I missed a key point in the setup for that one, that individual, Ms. Kessler, actually got that bottle from a completely different operation than Real Water in Tennessee. So that is not, the same. So
There's no foundation for where she got the bottle other than from her colleague, Mr. Neale. That bottle was introduced by Mr. Neale. She didn't have any bottle that she presented at the deposition. Is that what you're talking about? Are you suggesting she got the bottle from Real Water of Tennessee?
John, would you go back, please, to, let's go to,
Your Honor, Mr. Neale shows her a bottle.
no, I have the complaint. We can just go to the complaint. Let me just find that for you, Mr. Cavanaugh. Can you go to page 104, Mr. Stevens, of the motion? I think this is the right one. No, this isn't the right one. Let me see if I can find it. Let's try page 94, if you don't mind. Yeah, here we go. So, I think what we're saying is on the consumer complaint, this one says Real Water Tennessee, and I think on the testimony, there's a suggestion about Tennessee. If I'm wrong, you're very welcome to correct me after.
The witness is in New Hampshire or somewhere back east, and Mr. Neale has a bottle with him. that he shows her from another, wherever Mr. Neale was, Virginia or another state, that bottle is not connected to Miss Lois Kessler in any way. You're suggesting there's a bottle that from 2015 or 2016 that's evidence in this case?
I wasn't there, so I would invite Mr. Neale, if you don't mind, to address that.
Your Honor, I don't know that we need to spend an enormous amount of time on it, Your Honor. My recollection, Mr. Cavanaugh, was that the customer complaint form, and John, it should be adjacent to this one, I think, said that the witness called, it's not that one.
I understand what she said, but he just told the
Excuse me.
judge that there was a bottle that this witness has somehow had possession of. And
No, I'm not saying a bottle, I'm saying that she got her bottle apparently from Tennessee. I'm not saying that she's in possession of a bottle.
There's no evidence she got a bottle anywhere. She made a complaint to Tennessee. She said she got the number either from Sprouts or the internet. She didn't get a bottle from anywhere related to this complaint. That's what I'm objecting to the judge, that's being, I think, misrepresented.
I think that we're getting a little far afield. I mean, I invite the argument after, but I don't think that this is critical to waste time on now.
And objection noted, sir.
Thank you.
Your Honor, regardless, for Ms. Kessler, she's the individual who said it tasted very bitter. After that, continued drinking it for a number of years, had no issues with the taste of it after that. And then many years later, apparently says that she had developed fatty liver disease, but never had any liver failure, never had any acute non-viral hepatitis. Two more of these. Next up is Tang Tom Pham. This is actually a Real Water former employee. I think he worked at Real Water for about 2 years. I was at his deposition. Mr. Kemp, essentially what Mr. Pham testified was that he had received a phone call from Mr. Kemp's paralegal, I think a week or two before, and was asked about, some injuries and his neighbor and if he knew of anyone that ever become sick from Real Water. He said that he thought that his neighbors had perhaps become sick. He saw an ambulance, but he never saw them drink Real Water. He never had their medical records. Everything he had was, we'll play the testimony here for you, but everything that he learned was all secondhand information, essentially, hearsay. So with that, if we could play Mr. Pham.
So back to the complaints. You heard customers complain about the retail bottles? You heard of customer complaints about the retail bottles?
No, I didn't hear about it until I left the company, and my neighbor also, him and his wife went to the hospital because they bought some from Whole Foods, and that's when I heard about it. And I at the time, I just got let go within the company, and they were in the hospital for a few days.
What's your neighbor's name?
His name was Chip Couvet. I think I gave the information to Kelly.
Okay.
But anyway, so
you heard that your neighbor had been hospitalized for?
Well, I heard about it. I saw the ambulance came and him and his wife went first, and then the following day, he was the one that had to go to the hospital.
In an ambulance?
Also.
So your neighbor and his wife were taken to the hospital.
Correct.
By ambulance. And this was at a time when you were employed by Real Water?
No, that time I just quit.
And I think you testified in response to Mr. Kemp's questioning that you'd never seen your neighbor or his wife actually drink the Real Water, though. Is that correct?
Correct.
Have you ever seen your neighbor or his wife's medical records?
No.
Were you ever in the actual hospital when either your neighbor or his wife were hospitalized around this time period that you described?
No, because I took a business trip up to San Francisco, but I did saw the ambulance prior to me leaving to San Francisco for a business trip. And then when I came back, then I actually asked him what happened, and he goes, well, we got really sick from drinking, that his wife was in the hospital for at least 3 or 4 days. But again, you can clarify that with him, if you like, and you got his number.
Yep. Did you ever speak to any of Chip or his wife's doctors?
No, never.
Do you know Chip or his wife's actual diagnosis that they received from the doctor?
Well, I don't know until Bonnie told me afterwards, later on, that he got sick from drinking the water. Other than that, that was it.
But in terms of an actual medical diagnosis, you're
Yeah.
not sure of any specific diagnosis that he had from a doctor, correct?
No, correct.
And then in terms of your own expertise, do you have any sort of expertise in epidemiology?
Say that again?
Do you, in terms of your own expertise, do you have any sort of expertise in epidemiology?
No, I do not.
So for instance, for tracking or diagnosing diseases, do you have any sort of expertise in that field?
No, I do not.
And you're not a medical doctor, correct?
No,
Is that correct?
correct.
Is it fair to say that your only knowledge about your neighbor Chip's situation and his wife's situation is hearsay, meaning that it's all secondhand knowledge relayed to you from your neighbor?
Yeah, because he told me what had happened, and that's why I was shocked that that's what he told me. Other than that, that's it.
Yeah, everything you know is secondhand knowledge relayed from your neighbor, true?
Yeah, like you just said that.
That's Mr. Pham, and just to be clear about Mr. Pham, I think it's undisputed that he had stopped working at Real Water by that time period. So I don't think there's any evidence that Mr. Pham ever knew this while he was at Real Water, that there was any notice to any of the defendants here, including Real Water, in relation to his allegations about his neighbor. Finally, we get to the testimony of Jeffrey Desautels. We previously played, Your Honor, some of that testimony for the dogs and cats discussion that we had earlier today. He also alleged that his daughter may have had issues, and I think that came up briefly with the previous motion. I'm going to play that for the court, and then I'm going to ask Mr. Stevens when we get to the dogs and cats if he could just cut it off in light of Your Honor's prior ruling.
You know, my daughter's gallbladder had to be removed.
Approximately what was that?
2 years ago.
So today is 2022, that would have been in 2020?
Yes,
Yeah,
yes, before she left.
That before or after you heard of the outbreak?
I don't remember.
Okay. There came a time that you read the newspapers or...
I can almost swear you was before.
Okay.
Because she had gallbladder problems. You know, digestive problems. And then the doc said it was a gallbladder.
Any medical incidents involving anybody?
Nothing I can prove.
Any suspected medical incidents?
Well, of course.
Any indications of elevated ALT or AST readings? Those are liver enzyme readings.
I personally haven't. My liver functions fine.
Okay.
I'd have to ask my daughter.
That's Mr. Desautels in relation to his daughter. Again, no evidence as far as we're aware of any liver injury, liver failure, acute non-viral hepatitis. So with that, if we could switch over to the PowerPoint. Your Honor, I know that that's a lot. I know that there are a lot of different issues there. I think the issue that we're running into is that plaintiffs want to take all of these issues, 20 written complaints about all sorts of stuff, styrofoam, slight candy / soda-like scent, preformed resin, oily red substance, all the way down to these ones, with allegations about a gallbladder and whatnot. And they want to introduce all of these to the jury without regard to the facts, circumstances, or causes of those other incidents. Now, it's important for the court to look at these instances in relation to the allegations of plaintiffs in this case. That's the substantial similarity analysis, and I'll get to that in a moment. But we do think it requires getting into the details of these, and that's why I played them for the court, and specifically comparing each one to the allegations by the plaintiffs in this case to see if there is the requisite substantial similarity for these to be admissible. So this is the first page of it, and I'm going to go to the second page. Here are the rest of the ones. So we have 2 pages worth that they want to introduce. So let's compare this to what plaintiffs allege in this case. Your Honor, this is a case where I've highlighted the 2 plaintiffs that have alleged anything against my client, UNFW. Keith Haley alleges that he was diagnosed with severe liver failure and was hospitalized in 2019. And then, this is in the second amended complaint. That's paragraph 5. On paragraph 11, plaintiff Richard Belsky alleges that he was diagnosed with severe liver failure and he was hospitalized for 5 days in 2018. And I want to show you specifically what these 2 plaintiffs allege. We've taken the testimony that we've put in our motion and we've clipped that and we've made a short compilation. Your Honor, we're going to play that for you now. This is Keith Haley and Richard Belsky explaining, for instance, if they ever saw any foreign objects, if they ever had any bad smells, if they ever had any bitter aftertaste in any of the retail bottles of real water that they allegedly drank.
No foreign objects of any sort in the water that you saw?
No.
This is Keith Haley.
Certainly no mold or fungus or insects or cardboard or dirt?
No.
Did it look?
And Richard Belsky.
Yes.
No foreign objects?
No.
No, what's the right word, turbidity, cloudiness?
Not to my recollection.
Were the bottles you drank from all sealed, as best you could tell?
Yes.
Did they look, smell, and taste normal to you?
Yes.
No chemical smell, no off color?
Not that I know of or can remember.
If that had happened, you're not the kind of guy who, you would raise that issue to someone and make sure other people knew about it.
If something was off, I would probably raise that issue.
No chemical taste that you recall?
Not that I can recall.
Did it smell normal, as far as you recall?
As far as I recall, yes.
And did it taste normal?
Yes.
In fact, you liked all of those things enough to pursue the home delivery after drinking, correct? Okay. No chemical smell or taste?
Not to my recollection.
And no immediate symptoms or burning sensation?
Not that I can know.
And certainly no unpleasant physical sensations when drinking it?
No.
No burning or itching or?
No.
So, Your Honor, those are the 2 plaintiffs that allege anything against UNFW in this case, and those are their allegations. Their allegations are that they had retail bottles of real water. In relation to Mr. Belsky, he also has a 5-gallon product afterward. But they alleged that they had retail bottles of real water that had no foul smells, no foreign objects, no cloudiness, no bitter aftertaste. They were sealed bottles. They did not notice anything wrong with that water in any way, shape, or form. And then a number of months later, they alleged that they had some sort of liver failure or acute non-viral hepatitis from those retail bottles of real water. That is very important. That's the baseline that we got to compare these other consumer complaints to in order to see if they're admissible. So with that, I'd also point out that this outbreak obviously is an acute non-viral hepatitis outbreak linked to a brand of alkaline bottled water. This is an outbreak that relates specifically to liver failure or acute non-viral hepatitis. And I'm going to go quickly through this. I know that we've covered this ground before. This is Guinness, which we cite and which plaintiffs cite and rely upon. Guinness, which is 886 Nevada 408, explains that the relevancy of other accidents, whether prior or subsequent, depends on the purpose for which the evidence is offered. It cites Whitkin for that principle. And on the bottom here, I've included a brief chart, I'll be very brief on this, about the differences between using something for notice of a dangerous condition or defect versus as evidence of causation / defect / dangerous condition. There's a big difference there, and I know we've covered this a lot, so I'll be very quick, but for notice, this is relevant for negligence. This is to prove that the defendant had notice and that the defendant carried that duty if they were put on, that person that received that information had notice of their duty and was able to go investigate and try to resolve that in advance of the allegations in that specific case. This notice is not relevant for strict product liability. For the notice of a dangerous condition or defect, it can be used if the incident was sufficiently similar so as to put the defendant on notice of the alleged condition or the defect, and it cannot use subsequent incidents that's directly from both Guinness, Rheingold, and other Nevada cases. In contrast, if you want to use the purpose, use the evidence for the purpose of showing evidence of causation or defect or dangerous condition, this is relevant for negligence or strict product liability. And obviously, Guinness is a strict product liability case, so is Andrews. The substantial similarity requirement is heightened, and there must be admissible evidence. You cannot use hearsay. Because you are using this evidence for the truth of the matter asserted, the truth of the content of that document. You are trying to show that this other incident that allegedly occurred before at some other time is sufficiently similar enough that the jury should infer that the same cause occurred in the case before the jury. This is Harley-Davidson on these principles. So Harley-Davidson, this is Andrews versus Harley-Davidson. It's 106 Nevada 533. Plaintiff has a right in a strict liability action to introduce evidence of a substantially similar accident to prove that the design of the product involved in the accident is defective, and whether the jury may be allowed to draw an inference as to whether the defectiveness of a product from prior failures depends on whether the factors which produced the prior failures were substantially similar to the factors which produced the present failure. So that's what I've been attempting to do my best to describe. That, straight from Andrews, straight from the Nevada Supreme Court, explains that, whether this type of evidence can come in to prove a defect depends on whether the evidence relating to the prior failure is sufficiently and substantially similar enough to the current incident before the jury in order to allow the jury to essentially infer from that there is some sort of evidence of causation based off the prior incident. Here's how Andrews specifically applied that law. So Andrews was looking at whether certain deposition testimony should come in. And they compared it, just as I'm attempting to do to the court. They compared, here's the prior incident, here's the allegations by the plaintiff in the case. So, and the court went through, this is the Nevada Supreme Court, went through that analysis and said, all right, here's our comparison. Here's the deposition testimony from the other incident. Here's the plaintiff's allegations. Both men testified that their injuries, so I guess first I skipped it. It says both men had similar injuries. It's number one. Then both men testified that their injuries occurred when they were thrown against the gas tank of their motorcycles after it separated from their frame. Next, both men drove into the back of a car while traveling around 30 miles per hour. Andrews's and Zilkowski's motorcycle had an identical frame, engine, and fuel system. And the differences in their accidents are trivial and would have little or no effect on their injuries. Therefore, we conclude that the accidents were substantially similar and the court erred in not allowing Zilkowski's deposition into evidence. We believe, Your Honor, that we understand your discussion this morning over shown and the general principles around strict liability, and we do not dispute those. We do believe that the court needs to also engage in this substantial similarity question for each of these consumer complaints or deposition testimony that relate to other incidents that plaintiffs are trying to introduce. We do believe that this type of analysis needs to be done for each one, to see if they had similar injuries. Whether Lois Kessler has similar injuries to Keith Haley and Richard Belsky. Whether the styrofoam instance had similar injuries to Keith Haley and Richard Belsky. Whether the other circumstances that they allege here are the same, whether they were both sick around the same time, whether the onset is the same, whether you're drinking or consuming in this instance around the same amounts of liquid. So there are other circumstances that we do believe should be compared, and of course, to be very clear, we are not saying that they need to be exact. I think Andrews is very clear here. It says, if differences in the incidents are trivial, and would have little or no effect on their injuries, that a substantially similar incident can come in. We just, Your Honor, don't believe that the consumer complaints that plaintiffs are trying to produce are similar in any way. And in fact, on that point, not a single one of the consumer complaints that plaintiffs are trying to produce have anything to do with an allegation of liver failure. So, obviously the big allegation here against all the defendants, including, most importantly for me is UNFW, Keith Haley and Richard Belsky are alleging liver failure. So, if we do the Andrews versus Harley-Davidson analysis here, the first question we get to is, did they have similar injuries? And the answer across the board is no. So none of these alleged prior incidents that I went through have any sort of similarity in terms of the injury. Here's the second page showing, again, a bitter aftertaste. There's no allegation of liver failure. Fishy smell and black tarry tools, no allegation of liver failure. Immediately sick, this person drank too much water. No, it's not an allegation of liver failure. Many of these consumer complaints, the majority of them, involve no alleged injury at all. So obviously, as we went through, Your Honor saw there were some where people are saying they had vomiting or diarrhea or whatnot. However, a vast majority, these are the easiest ones that should be excluded immediately in our opinion. These have no alleged injury at all. So these are, the first one is Desotel Exhibit 20C. It's just having this non-conformance of the manufacturing process, a preformed resin or oil was in the water. 20D, strong chemical smell and water purchased from Chevron.
Here's my question.
Yeah.
What impact does the consumer expectation test have under the circumstances of this case? And doesn't that play a role? Because we're talking about, we're not talking about a Harley-Davidson failing to perform, we're talking about water. And what impact does that have? Because that's what I really want to know, because I understand what you're saying, some of these cases are different, but we're talking about water. We're talking about drinking water. And under those circumstances, what would the consumer expect?
Yes.
And I don't think they would expect tainted water in any form.
Well, Your Honor, so if
And especially when it comes to manufacturing and distribution and the delivery from a retail perspective.
So, Your Honor, on those points, if Keith Haley or Richard Belsky or these other plaintiffs against these defendants had alleged that they had, preformed resin in their water, then perhaps an ordinary consumer would say, we don't expect to have preformed resin and we're going to be able to sue real water for that. But the problem is, we're not to the analysis of consumer expectation yet. We're still considering what evidence should even go to the jury.
Okay, but does the consumer expectation test dictate the type of evidence that would go to a jury?
Your Honor, we don't believe that it does.
And why?
So we believe that, and although, I understand Your Honor is drawing a distinction between the motorcycle and the water, the exact same claims are alleged here. They're both product liability claims, and we think that the Shoshone case obviously was far before Andrews, and we do believe that Andrews was decided under that same framework. So this really is a question that comes before the application of strict product liability, before the jury would consider any jury instructions. This is a question of whether these should even go to the jury and whether the jury should even be able to consider this evidence. And based off of Andrews, McGinnis, and other case law, we don't believe that this evidence should even get to the jury for that consideration.
And the reason why I ask that, I go back to Shoshone.
Yes.
It is a bottled beverage type case. And this is some of the language out of the case. It's quote, we affirm the verdict and judgment since in our view, public policy demands that one who places upon the market a bottled beverage in a condition dangerous for use must be held strictly liable to the ultimate consumer for injuries resulting from such use, although the seller has exercised all reasonable care and the user has not entered into a contractual relationship with him. And that's kind of what my question is, because all strict product liability cases are different. We can agree with that. And what am I to do? What guidelines should I look at when it comes to bottled beverages or bottled liquids that have been prepared for human consumption?
Yes, sir. So we don't dispute your analysis of Shoshone and how it's applied to the principle of strict product liability. We do believe that that's a completely separate issue, though, from the substantial similarity analysis for other complaints. And I think that where the court should go for the substantial similarity analysis and the analysis of other complaints is Andrew versus Harley Davidson, Beniti, which is plaintiff's own favorite case that they identified, and they said that it, they pointed out that apparently it's from the Fourth Circuit where Mr. Neale comes from. The Guinness case, those are the Nevada Supreme Court cases that deal with this issue. Before we get to the jury and we give the jury instructions, and then they're deciding on whether an ordinary consumer would expect one thing or not in relation to plaintiff, we have to see if these other incidents, which are non-parties, I mean, these are people that are third parties, they're not in the case. These are a lot of times hearsay, third-party documents, whether those should even be introduced at the trial. So, the consumer expectation analysis, the, risk-benefit, which we understand, Shoshone and the line of cases that you said today, that does not bear on whether this evidence is relevant. That does not bear on the substantial similarity analysis.
And why?
It does not, because this is before you get to the jury. So,
Ultimately, I understand my role, I'm a gatekeeper, but I have to decide what type of evidence would be relevant for the purposes of admissibility at trial, right?
Yes.
And I think what you're saying, look, Judge, it doesn't matter whether the water's tainted or not, unless they suffered a liver injury, it's not relevant for the purposes of strict products liability vis-a-vis the production of beverages. And it doesn't go to the heart of the capabilities of the product manufacturer and bottler under the facts of this case. And so they should get a pass on certain problems, but unless the problem is specifically relating to the specific peculiars of this case, it doesn't come in.
Your Honor, I'm not suggesting that my client or defendant should get a pass for no reason. What I'm explaining to the court is the public policy reasons in the case law supporting these other incident evidence. And this is across the board. I was looking at Wright and Miller last night. It has the same stuff in Wright and Miller.
Well, Wright and Miller's not a tort.
We
can agree that deals with the rules of civil procedure. And the reason why I ask that is essentially this, and they go on, they cite Griedman versus Yuba Power Company, it's a California case from 1962. And the reason why I think it's important to really focus on this, because one thing we do know for sure we can agree upon is this one fact. As recently as 2017, our Nevada Supreme Court has looked, we're not going to deviate from the the consumer expectation test, and they've said that. That's what Justice Stiglitz said. And so when I look here, and that's one of the questions I have, where do we go? Because this is a peculiar case. This is dealing with bottling of beverages. And water is a beverage, I guess, or whatever. But I mean, that's what we're dealing with. And then right here, they cite Griedman versus Yuba Products, and this is straight out of the Shoshone Coca-Cola Bottling Company case. And it says there, Justice Traynor wrote, the purpose of such liability is to ensure that the cost of injuries resulting from defective products are borne by the manufacturer that puts such products on the market rather than the injured persons who are powerless to protect themselves, period, close quote. So what do I look at? And that's when I'm looking for guidance for counsel from both sides. What do I do with this?
Yes.
Because I'm not convinced that unless it's the facts fit in this small hole, and everything has to be on all fours as to whether it comes in.
And Your Honor, we are not suggesting that it has to be an exact matchup, and I think the case and the quote that we showed the court shows that that's not the case. There can be trivial differences that don't make any difference in the overall injury pattern and the causation analysis. But this analysis is separate and apart from the Shoshone strict liability, Yuba Power analysis that and issue that the court is going to. So that is about privity and strict liability, joint and several liability, obviously the public policy favoring consumers over manufacturers, and that obviously, as the court said this morning,
I mean protection of consumers. And here's my point. And I don't know this for sure, and I'm quite sure we'll hear more testimony and more argument. But when it comes to the manufacturing of product in the form of water and or beverage, what should I look at? What goes to the jury? What type of evidence should I look at regarding the manufacturing processes of the manufacturer? You know, how far do I go, you know, when it comes to similar or substantially similar events? That's what I'm really kind of focusing on, because
Yes.
that's what I want to know.
Yeah, so Your Honor, you know, and we appreciate that question. So, you know, and this is slightly different than what Real Water will describe as its manufacturing process. They're enabled to, you know, the plaintiffs are enabled to ask them questions about how the product was manufactured. These go to the non-conformances or the other incidents or allegations. So this is as an example, if you know, own a hotel and someone slips on the steps outside and then
No, it's
someone.
not. No, it's not.
It's all the same
No,
public
it's
policy.
not. That's premise liability. That's negligence. I've tried those cases. It's not the same. It's notice.
But-
Knew or should have known. We're talking strict products liability. We're focusing on the safety of the product, right? That's a big difference.
Yes,
That impacts your credibility. I don't mind telling you that.
yes, Your Honor, what you identified is a difference, but this is all the substantial similarity analysis. So, and as I've explained, there's the notice
You're talking about
consideration.
notice regarding slip and fall and trip and falls. What are we talking about there?
Let me
I
go
mean, it
to,
has nothing to do with the focus and thrust as it pertains to the consumer expectation test in this case,
So-
in this state, and that's what I'm really looking for. I'm looking for guidance.
let me,
What comes in and what doesn't come in.
let me go to causation, defect, or dangerous condition then. So I think, you know, I've moved on from notice. This goes to dangerous condition, defect, as Your Honor said, strict liability. That's completely under Andrews versus Harley Davidson, and it's completely under Guinness. Those are the two strict liability cases for Nevada. They both explain that there has to be substantial similarity between the incidents for anything to be admissible. And as you'll see in those cases, this consideration for substantial similarity comes before it reaches the jury. I mean, these are motion limine. This is, as you said, Your Honor is acting as the gatekeeper. That is separate and apart from the consumer expectation test, and is separate and apart from the public policies that Your Honor has identified in relation to consumer protection. So, you know, we would encourage, you know, the court to, and I know you have, but we believe that Andrews versus Harley Davidson and Guinness versus Mapes are the two controlling Nevada cases here. Your Honor, and I just want to be clear, we are not saying, as I've said, we are not saying that it has to be an exact matchup, and the case law specifically says substantially similar for a reason. So this is the first one that I'm showing. I mean, I've already shown that there's no liver failure. Now on these 2 pages, I'm showing there are 14 of these 20 complaints, Your Honor. 14 of the 20 complaints where there's no alleged injury at all. So obviously, you know, I mean, at least based off of Andrews versus Harley Davidson, a plaintiff in a case where they're alleging a specific injury, such as in that case, it's the motorcycle that slammed into a car at a certain speed, something happened with the gas tank. You know, if someone else has an issue and they couldn't put the brake up on their motorcycle and they say that it's shoddy manufacturing because they couldn't put the brake up, that does not bear on the question of whether in that lawsuit the gas tank and the motorcycle was defective and whether that defect actually caused the plaintiff's injuries. Those are separate things, and you do not get to introduce evidence.
You're saying that's a product misuse or something? I'm trying to figure that out.
No, I'm not. No, I'm not. No, I'm giving an example that there are many defects that can happen with a product. I think, you know, hopefully we can agree on that. So, and I think it's a little bit easier to, you know, to conceive, for instance, for a motorcycle. You can have a defect with, let's say, the brake, or you can have one with the steering, or you can have one with the wheel. With water, you know, I think maybe that's where.
Well, that's what I'm coming back to, because
Yes.
motorcycles are different. I don't mind saying I used to ride Arcus.
Yeah.
But I understand motorcycles. I do.
Yes, and so, Your Honor, what needs to be considered here is you look at everything in comparison to plaintiff's allegations. Plaintiff's allegations here are that the water had hydrazine in it. Now, what happened in these other incidents is, number one, had preform in it. That's plastic. Number two, you know, it had a strong chemical smell. They said the hydrazine has been scentless for all these plaintiffs. You know, number four had a slight candy/soda-like scent in a cloud substance. Completely different. There's no hydrazine here. So the alleged defect here that we're comparing it to is that hydrazine. It's that, there was hydrazine in it that supposedly caused, according to plaintiff's theory, it allegedly caused liver failure in these plaintiffs. For us, we care about Keith Haley and Richard Belsky. For the other, it's the other 5 plaintiffs as well. That's the comparison that needs to be made. That's the alleged defect by plaintiffs, and then we need to compare it whether the defect and the causation in the other incident, is substantially similar or sufficiently similar, excuse me, such that the jury should be allowed to look at that evidence and infer, based off of this other evidence of an incident that is not before the court, that a lot of times you don't even get an investigator or anything like that, whether the jury should be able to infer based off of that causation in the case before the jury. And the Supreme Court has said you're only allowed to do that because of the severe prejudice that can happen. And dating back, and I traced the history for this all the way back last night, and I put a couple slides in. This goes back to a couple Southern Pacific cases in the 60s, El Dorado in the 60s. All of them say that error is manifest if you allow just anything in, because obviously, these incidents can be dissimilar, and it allows the jury to infer. So, I want to emphasize here as I move on that there are 14 of these complaints that do not have any alleged injury whatsoever. They're completely separate and apart from the allegations in this case. Once again, the allegations for plaintiffs are no unsealed bottles, no foreign objects, no dirt or dust particles, no styrofoam, no manufacturing resin, no foul smell, no bitter taste. Completely separate and apart from those 14 that I just showed, Your Honor. No lemon taste. Here's El Dorado. El Dorado is a 78 Nevada 507. It's a 1962 case. It's cited in the other cases we've been mentioning. It says the admissibility of evidence of prior accidents in this kind of a case to show notice or knowledge of the danger causing the accident is generally confined to situations where there are conditions of permanency. And I think we've established, I'm not going to spend any more time on notice or knowledge. I only mention this because to the extent anything that's hearsay, such as Tom Pham's testimony, tries to come in for the purpose of notice, there has to be a condition of permanency showed based off of Nevada Supreme Court case law. That's El Dorado, and then there's also Southern Pacific versus Harris. That's 80 Nevada 426. That's a 1964 case. Again, this one is notice. I'm going to go very quickly. It just says the mere occurrence of many prior accidents at the same crossing without more tends to show that the crossing was. It says it was a theory of the plaintiff at trial and in this court that the mere occurrence of many prior accidents at the same crossing without more tends to show that the crossing was inherently dangerous, and further, the Southern Pacific company was placed on notice to do something about it. But most of the cases collected.
Is that a strict liability case?
Either one of those, that's an case.
I mean, it can't be, it's not a product.
Yes, and your Honor, as I said, I am only.
Because I don't want to conflate different theories of liability.
I don't either.
understand breach of warranty, I understand negligence-based cases, I understand what strict products liability is.
Yep.
I understand the consumer expectation test. And so I'm trying to I need guidance on what should come in and why.
Yes.
But I don't want to look to negligence cases, really and truly, when it comes to, I guess, ultimately some of the, I mean, I do realize we have a negligence component here.
Yes.
But I'm looking at it from, I'm really focusing on, I guess, the thrust of the motion and focusing on these prior events involving, I guess, allegations as it pertains to real water. And
Yes.
so I'm trying to follow you, sir, and I want to make sure I understand. And of course, we're not going to get done today. We'll hear from the joinders tomorrow.
Okay.
Mr. Odou, yeah, we'll hear from the joinders, and I know you'll probably get a chance to tell me what you think, and I'm going to listen, of course, and Mr. Rasmussen, I'm going to listen to you, sir.
Thank you, sir.
And then we'll hear from Mr. Kemp. But I'm looking at to the peculiar facts of this case.
Yes, Your Honor.
Yes.
Yes, and the only reason I mentioned notice is because there is a negligence claim, as Your Honor pointed out, against our client, against the other defendants. And I go back to the important thing is what the purpose is of that evidence, why it's coming in. And so, if nothing's coming in for notice, it's very easy. But that means, no hearsay evidence can come in because, as I've said, no hearsay can be used for defect, causation, dangerous condition. Now, the only other thing I want to emphasize, and then I'll try to get us out of here, shortly, is that if something comes in for one of the claims, so if something's coming in for, notice because it's hearsay that plaintiffs are trying to introduce, then that cannot be used in the strict product liability claim against any of the defendants. So to give the court an example on that, and this is the court's question yesterday. The court's question.
I understand what you mean.
Yeah, so, if Real Water was shown to have notice of a certain incident, and that comes in for notice because it's hearsay, then that cannot then be used for strict product liability against Real Water because it's hearsay. So it can't be used for causation defect. So under Shoshone and the privity rules that Your Honor has specified today, that could not be used against Real Water. It could not be used against anyone else in that strict product liability chain, including United Natural Foods. So I think, there is a couple step process that needs to be done. Number one, each consumer complaint needs to be matched up and compared to the allegations by plaintiffs in this case, where there's no foul taste, no chemical smell, only sealed bottles, no cloudiness, no, foreign objects in them. And here they're alleging liver injury. In every single one of the ones in our motion, there is no allegation of liver injury, of liver failure, of acute non-viral hepatitis. So based off of these reasons, Your Honor, once the court then compares the substantial similarity analysis and also considers whether the incident is hearsay or not, such as Tom Pham's testimony is direct hearsay. He admitted as much. He said it was secondhand knowledge, hearsay. That could only potentially come in for notice, which is back to negligence. And even if that gave notice to Real Water, which there's absolutely no evidence that Real Water had notice of that for Tom Pham, none of the other defendants for sure didn't have, no one else had notice for sure. But even hypothetically, if Real Water did, and again, I have no reason to believe that they did, but even if they did, that would only be usable for negligence against Real Water, would not be usable for strict product liability against Real Water or anyone else in that chain. So, Your Honor, I think that those are the considerations that the court needs to go through. We would ask Your Honor to compare those consumer complaints. We do believe that they should all be excluded for the reasons we've described, including because there are no other allegations of liver failure or acute non-viral hepatitis. But certainly, there are over a dozen, at least 14 where there's no injury alleged. They're completely afield of this case. And we certainly believe that that analysis needs to be done. Thank you, Your Honor.
Thank you, sir. And what time tomorrow?
Tomorrow, 10.
Is that fine?
10:30 is fine, Your Honor.
Thank you, Your Honor. Mr. Kemp, fine?
Yes, Your Honor.